Carmel Sepuloni.
Mr Chair, I just want to raise a few points that haven't been raised already around the purpose of this bill, and then I'm going to go to clause 43. I raised some issues on that before, but the Minister hasn't responded yet to it, so I'm just going to reiterate those. Mr Chair, looking at the purpose, so the purpose of this Act is to establish a child sex offender register that will reduce sexual re-offending against child victims. One issue with that we haven't discussed in Select Committee, and I haven't heard any mention of by the Minister, is actually what the anticipated reduction is. We know that the National Government likes to set targets, and so what is the reduction that the Minister expects to occur here with regards to sexual re-offending? And I think it's really important to point that out, because the evidence we were presented with at Select Committee did show that actually only about 1% of all sexual offences will end up with a conviction in the criminal justice system. So how much of a reduction are we going to see with re-offending, given that that's the case? I also think it's important to actually focus on that word re-offending. This is not going to reduce the sexual offending against child victims. It's the re-offending against child victims, and the re-offending that has gone through the criminal justice system. Keep in mind, and ended up in conviction, that 99% of the sexual offending against children that goes on does not even end up with conviction through the criminal justice system. So I think it's worth discussing that. It says after it states reduce sexual reoffending against child victims, it says, and the risk posed by serious child sex offenders. I think, we need to keep in mind that when we're talking about serious child sex offenders here, we're talking about the ones that have been convicted. We're not talking about the serious child sex offenders out there that we know exist that have not been convicted or not been discovered, Mr Chair. So it's important to mention that. Part A says providing government agencies with the information needed to monitor child sex offenders in the community, including after the completion of the sentence. I think my colleague Lewis Awar brought up absolutely why that is important, so we support that. But Part B says providing up-to-date information that assists the police to more rapidly resolve cases of child sex offending. So when we're looking at B, for the purpose, we have to keep in mind that that is after the fact, because you're talking about providing police with information to more rapidly resolve cases of child sex offending. So actually it's hard to reconcile that with the original statement in the purpose, where it says to reduce sexual reoffending against child victims, because Part B of the purpose is just actually to provide police with information so they can resolve child sexual offending cases. So I think it's really important to talk about that. Now, I talked about clause 43 earlier, and I do want some answers from the Minister, Minister Antoli, and that is clause 43 is in relation to disclosure of information to affected people where a threat to child safety or welfare exists. So we know that this particular clause means that it's not just about sharing of information between government agencies. It opens it up to third parties. And I think it's really important that we in the House are clear about who those potential third parties are. What are the safeguards in place with regards to protecting that information? Who is an appropriate third party? So just some examples. How will the risk be assessed before the decision is made to pass that information on to the third party? Who will be making that decision and who will be passing that information on to the third party? And what, Mr Chair, will the consequence of sharing that information outside of the parameters of the agreement, in terms of if it's given to the third party and it's supposed to stay there, what are the consequences if that information is passed on? Because I'm thinking here, one example of a third party discussed in Select Committee was a school board of trustees. Now there you've got concerned parents. Yes, they are governing the school, but you can imagine that it would be very difficult for them to withhold information from the rest of the community if they then become aware of the fact that there's a convicted sex offender living in their community. So what then, Minister, would the consequences of sharing that information be? I think we're just lacking a little bit of detail and explanation around that particular clause, clause 43. So if the Minister can answer some questions about that, then I think that that would hopefully give some people a bit of peace of mind, or potentially give us guidance in terms of further changes that need to be made.
Mr. Chair. The Honourable Anne Pollock.